case briefs, and so much more. LSData's got what you're looking for.
In a 2010 legal showdown that revolved around the lesser charge of voluntary manslaughter versus murder, Jack Edwin Suprenant Jr. found himself grappling with the Indiana Court of Appeals. The case, Suprenant v. State, examined the intricacies of legal argument hinging on sudden heat, typically a mitigating factor reducing murder to manslaughter, provided specific circumstances exist. The premise is simple. If a person under extreme provocation becomes irate enough to kill, they could face a charge of voluntary manslaughter instead of murder. However, the presence of a deadly weapon or clear indications of cool-headed deliberation are critical factors that could impede this argument, painting a clear picture of premeditated murder. Words alone barely cut it as grounds for such provocation. The gruesome circumstances that led to the lawsuit involved Suprenant savagely assaulting his partner with no less than 49 stab wounds, all in full view of their 3 minor children. Arguing an appeal that the initial trial court erred by not providing the jury with a voluntary manslaughter instruction, Suprenant further contended that his sentence was unduly harsh. However, Suprenant's arguments fell on deaf ears as the court unequivocally dismissed his appeal. They cited that the victim's actions, limited to merely packing her belongings, did not go far beyond mere words, thus not enough to meet the sudden heat defense threshold. Furthermore, the court clarified that Suprenant had sufficient time to deliberate over his actions and could have sought intervention. The court's ruling was unflinching in deeming Suprenant's sentence fitting, given the sheer brutality of the crime committed. Consequently, Suprenant had no choice but to serve his murder sentence, as the court upheld both his conviction and sentence. Previously, the lower court had ruled that ignoring the provision of a voluntary manslaughter instruction to the jury during Suprenant's trial was not a lapse. This was also in line with the upper court's affirmation of Suprenant's sentence on appeal.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.